500 million was from the government. And from the conduct and the evidence on record, he worked towards spending that money without following the guidelines. Some of the journalists who were paid allowance as Team Kenya ended up receiving a second allowance while in Rio. So the evidence that there was a saving of 200 million is a woodwing to the public that there was prudent spending, while in actual sense the budget was exaggerated. So as stated yesterday, the budget ought to be drawn to the specific need. I've also taken into account the submissions that in mitigation that the fifth accused was acquitted. The acquittal of the fifth accused person does mean that the offense may not have occurred. The acquittal was on the basis that the prosecution failed to prove the case against him. The fifth accused indeed is admittedly that as the CDM prepared the documentation, submitted the list for payment, pursued the payments, and ensured their travel, while he was well aware that people like the NOC president, the Secretary General, had their expenses for travel, accommodation, and even allowance, plus that of their accompanying guests, borne by IOC. A lot was required from the fourth accused person as the CDM. As admitted in his defense, this is not his first role as a CDM. He has been a CDM in the past, and he knew better that the two ought not to have been included in Team Kenya together with their accompanying guests, and that tickets ought not to have been issued in their names, and that the allowance ought not to have been paid to them. So the fourth accused cannot escape from that liability. In any event, the court was told in defense that the accounts have been frozen. In that event, if money was really paid into the accounts of the fifth accused person, the other corruption fighting agencies, such as asset recovery, is at liberty to move towards recovery of such amounts of money. Every charge and every count against each and every accused persons ought to be determined on its merits. An acquittal of one charge does not extend to a verdict of guilty or not guilty on another charge. The government of Kenya was made to bear a huge budget of 500 million, while NOC bore a budget of 83 million. The fourth accused was the chef de mission and did most of the accreditation, and almost the entire steering committee was accredited to travel, and all the officials were accredited for travel. This he did with full knowledge that at the DRM, that is the delegates registration meeting, Team Kenya was allocated 125 beds, 80 for the athletes, and the remaining for the officials. That could have guided the CDM the number of officials to invite to save the country and the management of the team. The court has been also told in submission that as a CDM, the fourth accused was not a public officer. It is undisputed fact that until he retired, after the Rio Olympics, the fourth accused was a senior police officer, and he testified to this court that at the time of the offense was indeed a law enforcement agency. Equally, it was his defense that the role of a CDM is usually reserved for a uniformed officer, either from the police, the prisons, or the defense force. It is on the view that at sometimes it is difficult to separate a person from the role, that the court is of the considered view that indeed he was given that role of CDM on account that he was a police officer, and it is that position that enabled him to serve at NOC. So the court is certain that he was within that description. On the media, that has been mentioned by both Mr. Bosek and Mr. Sagana, the court will appeal to you to endeavor to report accurately, as the misreporting sometimes not only misinforms the public, but it also may injure the person against whom the report is being made. The court appreciates the submissions on the Sentencing Act, and it's also guided by the stare decisis, especially the Muratetu case, in which the mandatory sentence was opened and the courts given a leeway to give lenient sentences. So I think on the media, have been mentioned, media is encouraged to do accurate reporting to avoid misleading the public and also injuring the affected party by the misreporting. So the court has taken into account that both accused are of first offenders. It has equally taken into account the age of the second accused, the age of the fourth accused, who is a retired officer. I've also taken into account that by the time the first accused instructed that PW4 and two others be included in Team Kenya, there was no negative publicity. The negative publicity emerged much later when they were already in Rio. The first accused was actually in attendance and chaired part of the steering committee. Some of his officers attended the steering committee. Nothing prevented him from requesting the three to be accredited before the steering committee was resolved. He arbitrarily forced the three to be included in Team Kenya after obtaining Brazilian visa through the embassy, which was contrary to the Olympic accreditation which was given to the rest of Team Kenya. Both the first and the fourth accused were entrusted with leadership to deliver Team Kenya to Rio and to bring good performance. They managed to bring good performance, but in the process, the the government of Kenya lost a huge amount of money, and this brought bad image, especially when the story was aired through the media. The court is called upon not only to give a retributive sentence, but also restorative sentence in bid to recover the amounts lost. Indeed, as earlier stated, the accused persons did not draw any benefit. As such, the Section 48B will only apply on the loss. The court is also enjoined under Article 159, the spirit of the Constitution, to apply the law and the merits without necessarily being hampered by technicality. So while taking into a wholesome the mitigating circumstances, the submissions from both sides, the court will pass out and mete out the sentence as follows. The first accused, on count 2, Section 48(1), he is fined Kenya shillings 300,000 in default to serve 1 year imprisonment. In count 2, count 2, Section 48(1)(b), the amount of lost that was proved to the record of the court is Kenya shillings 450,000 times 2, that is 900,000 in default to serve 1 year imprisonment. Count 3, Section 48(1), the accused is fined 300,000 in default 1 year imprisonment. The mandatory Section 48B on the amount lost, that's 450 times 2, 900,000 in default 1 year imprisonment. Count 4, similarly, 48A is 300,000 in default 1 year imprisonment. And the mandatory sentence under 48(1)(b), 450 times 2, 900,000 in default 1 year imprisonment. You have 14 days to appeal from the decision of the court. For the fourth accused, he was convicted in counts 5, 9, 11, 12, 14, and 15. It's good to set the record straight at this moment that, equally as stated, the fourth accused did not receive any benefit, but rather money was lost under his leadership. So the court will apply Section 48(1)(b), 1A, and 1B, the mandatory sentence for the loss. So in count number 5, 1A, the fourth accused is fined Kenya shillings 300,000 in default 1 year imprisonment. The mandatory sentence under Section 48(1)(b), Kenya shillings 9,795,000 times 2. The amount is 19,590,000 in default to serve 2 years imprisonment. Count number 9, under Section 48(1), the fine is 300,000 in default 1 year imprisonment. In respect of Section 48(b), the mandatory sentence on the amount lost, that is 15,389,000 The fourth accused is fined Kenyan shillings 30,779.70 in default, 3 years imprisonment. Count number 11, 48-1, 300,000 in default, 1 year imprisonment. Section 48(1)B on the mandatory sentence. I need to point out on this is section 49. Mr. Bosek, for your benefit, I had referred to the evidence of Madam Rumbo, who said when the allowance is not enough for any institution, SRC is always ready to hear a review, and that's what the court expected the fourth accused to do, to seek a review from the SRC. So on count 11, that is 300,000 in default, 1 year imprisonment. The mandatory sentence for the loss incurred, 19,549 times 2, that is 39,098 in default, 3 years imprisonment. Count number 12, section 48(1)A, 300,000 in default, 1 year imprisonment. Mandatory sentence for the loss, that is Kenya shillings 4,983 times 2, that is 9,967 in default, to serve 1 year imprisonment. Count number 14, 48A, 300,000 in default, 1 year imprisonment. Mandatory sentence for the amount lost by the government of Kenya, which is 5,353,000, 532 times 2. The fourth accused is fined Kenya shillings 10,707, default, 1 year imprisonment. Section 4, count 15, the last count, section 48(1), fine 300, default, 1 year imprisonment. The mandatory sentence for the loss of 1.9 million, the total is 3,900,000 in default, to serve 1 year imprisonment. 14 days right to appeal is explained. Okay. Yes, Mr. Sagana.
May I request a certified copy of the sentence? And Your Honor, my apprehension of the time it will take for certification of the sentence, may I request for either just the final order or certified handwritten copy of the sentence, which is mandatory now for purposes of payment of fines following the central bank guidelines. It's my apprehension that it may take a while to make this payment, so to get a certified copy of the handwritten, just for purposes of using that at the bank, for purposes of payment. And finally, upon this payment, the accused has been on a cash bill of 1 million shillings, which was granted pending the hearing and determination of these proceedings. I humbly request that that be released to him.
Was he the depositor?
Yes, he was the depositor. Equally, He also deposited his Kenyan passport and diplomatic passport as a bail condition. And upon payment of those fines, he requested the same ministry. That will be all. I'm very good.
Yes, Mr. President. Yes.
We would like to judgment and the sentencing notes that you have made at this agreement. And for the second offender, Your Honor, we wish to make the following application under the provisions of Section 356 of the Civil Procedure Code.
Civil procedure?
Civil Procedure Code,
Yes.
75.
Civil procedure or criminal?
Criminal procedure, sorry,
Okay.
criminal procedure.
Okay.
We are asking for the following: certified copies of the judgment, certified copies of the sentencing notes, and that the Honor, the amount that you have penalized the second offender is too huge an amount, and we pray that granting bail and also stay of the execution of the sentence to enable him file an appeal. Your Honor, I would ask that you impose necessary terms which you think will be reasonable to ensure that within 1 week, today and tomorrow, subject to availability of certified copies, we will have filed the appeal. We are appealing against the sentence, and we believe that we have a very, very strong case, Your Honor. Your Honor, in imposing the terms for stay, there are already those terms that are in place. One, your second offender's passport is with the court. Is also the 1 million shillings, which was deposited as a cash bail. Your Honor, you could impose any other term, like probably that he be taken back to Sibiri police station for that 1 week. What we're asking is that there should be a stay. Your Honor, Section 356(1) gives you the jurisdiction to grant this prayer. You can bring the High Court or the supporting court which has convicted or sentenced a person may grant bail or may state execution on a sentence or order pending there, entering of an appeal, and on such terms as to the security of the payment of money or the performance or non-performance of the act, or the suffering of any punishment ordered or in the sentence the order as the reasonable to the High Court or the subordinate. So, Your Honor, we do pray that we will impose certain terms, but definitely the huge fines. Yes. Your Honor. Yes, Your Honor, we are saying that this court has a duty to ensure that justice is served. Consider the following, Your Honor, that the accusers throughout the trial for the last 5 years been on bail and he has not attained one time of Second, Your Honor, putting or imposing a total sentence right away will affect even the physical health and the psychological of the offender. That's Your Honor, we are worried because of his age. And the COVID-19 pandemic has explained during the investigation, Your Honor, that this could be a real challenge and is a matter of concern. Yes, so Your Honor, we do pray that the grant us pending appeal, and that in 1 week, the government has mentioned in 1 week with file the appeal, certain because of availability of the legal documents that are requested from this one of the court. And Your Honor, we appreciate the fact that you have cleared the record straight that my client never benefited from a single coin, is not a beneficiary, but these monies were paid to other Kenyans. I say no more. Thank you.
Is your client the depositor of the cash bill or is deposited in somebody else's name?
Sorry, Madam?
Is the fourth accused person the depositor of the cash bill?
It's supposed to be the cash bill is deposited.
In his name?
I think so, yes.
Okay. Prosecution?
Thank you. In response to the application, the pending appeal, the prosecution went to the process that application on the basis that this court is functus official, that it has dispensed its duty.
Please proceed.
There are Article 165 and Article 50. And the Criminal Procedure Code is clear at the point when the court delivers its judgment, goes ahead, considers the submissions made by both parties during litigation, and submissions on objective impact statements. 165, the Constitution. Your Honor, from the reading, Your Honor, of Section 356(1),
Section?
356(1) of the Criminal Procedure Code states that the High Court or the subordinate court which has convicted or sentenced a person may grant, may. It is a submission that it is not mandatory. In light of that, Your Honor, the reasons that have been advanced to you to grant bail pending appeal arise out of a sentence, Your Honor, or sentences and fines that are provided in law that the court has in detail considered submissions on mitigation and submissions on the impact of these offenses. Your Honor, the role of the court is to be just and fair to all the parties that are before it. And therefore, it is our submission that the proper forum for the said application, now that the court is functions official, is in the High Court. Your Honor, it has also been submitted to you that for the accused to be granted 1 week. Your Honor, it is not for an accused to make determination or set conditions or guidelines on what the court is supposed to do. That buttresses our submission that the proper forum is the High Court, and this court, from the reading of section 356(1), is not under mandatory provisions supposed to grant that right. Therefore, Your Honor, it is a humble submission that the said application has not met the requisite provisions of law to be granted, and the same should be dismissed. It's been submitted to you, Your Honor, that the court should consider remanding for the accused that we give pending appeal. Your Honor, it is a submission that the court being functions official, the accused stands convicted and facilities of the police that remain as facilities for remand of suspects. So the status, Your Honor, has changed. The accused person is now convicted. Then on the other submission that was made, it is a submission that the facilities which the court will deem fit even after passing the sentence have all the necessary facilities to ensure that the health of the further accused person is taken care of. Yes, Your Honor.
The sentence specifies in the default part.
Yes.
Specifies the facility.
Absolutely. Yes.
Yeah, so there is no doubt about
Yes.
the facility the court has prepared.
Thank you.
If you can just respond specifically.
Specifically, Your Honor, on that regard, Your Honor, I was just responding that the said facilities have the capacity to ensure that the health and the safety of the accused person is taken care of. And it's not been submitted to you how that cannot be done in the safe facilities. Therefore, it is our humble prayer, Your Honor, that the said application should fail in the first instance.
Ms. Kibali, you want to address the court?
Yes, and in terms of my senior has stated that I'd also wish to apply for certified statements, sorry, sentence, copies of the sentence and the judgment.
Okay, thank you.
Your Honor, I thank you for make a brief reply.
Yes, please respond, Mr.
Yes, first, Your Honor, Article number 165 of the Constitution talks about the establishment of the items. Your Honor, the state is not being handled according to the Constitution because it talks about there is a status report. Your Honor, I do not know this. I'm very sure of the court that I'm in today, this afternoon. Your Honor, secondly, factors official only relate to the followers. That you have rendered the judgment, you cannot change that judgment. That you have also rendered the sentence, and you cannot change that sentence. It can only be overturned in another court or different decision. So factors official only relate to those two aspects. Your Honor, the state has equally quoted the provisions of the civil of the criminal procedure, which I remind of. And they are rightfully saying that it's made. I think I read, Your Honor, and I also emphasize the fact that you have a very wide discretion regarding bail. You could even, Your Honor, allow the offender to remain in the same terms that were imposed during the trial. So, Your Honor, you have the decision to grant bail, and this has been clearly stated in section 356(1), Your Honor. And the law has given a leeway on what can be enforced by the court, either the High Court or the subordinate court. So you do have the decision, make the decision, and you have the decision. It says it's may, it does not say shall. I never read shall, I said may. So on the basis of that, Your Honor, the health of the accused person is better off not being, stay in the most appropriate place in our
the ruling of the court. Yes, the court has keenly considered the application by Mr. Sagan and Mr. Bosek and the response by Mr. Riungu and Ms. Kibali for the state. On the request of proceedings, the court hereby orders that the state be given a certified copy of the judgment and sentence as sought. And for the first accused, the defense also to be granted certified copy of the sentence or order upon the payment of the requisite fees. So whatever you pay for is what you'll be given. On the application by Mr. Bosek, the court has just meted out a sentence on this matter. In my view, the sentence meted out is lenient and reasonable in the circumstances. If I had no doubt whatsoever, I'll have ordered otherwise. For now, the court is not convinced that there is a basis to disturb that sentence and to exercise the discretion under section 356 of the CPC. On account of ill health, the court will direct that the fourth accused be accorded treatment at the prison infirmary, and the prison clinic shall be at liberty to refer him for treatment as they may deem. So let both parties, or rather both accused persons who are now convicts, comply with the orders of the court. So it is accordingly ordered. You have 14 minutes to appeal. You will be satisfied with the end of the decision of the court. Okay, all right. Sorry about that. It has been a long day. Sorry about that. Let me just make an order that the sureties, if at all, are hereby discharged. To be returned to them in Okay, the sureties, if at all, are hereby discharged on the securities to be restored back to them. In event of cash bail, the same to be refunded to the depositors. The rest of the orders on the passports release, I think let them be made at the appropriate time. Once they are released, just write a letter and the court will comply immediately. Yeah. Anything else? That is all.
That's all about that.
Thank you. That's all from the prosecution? Okay. Can I have my way out of here?
Si sahi. Acha niandike committal kwanza.
Tutapatia sentence pekee.
Acha tuniandike committal alafu tutakuja registry mchukue the rest.
Sawa.